Hello everyone, my name is Scott Aubrey. I'm the owner of Aubrey Law. We do estate planning and probate, and today's topic is 3 reasons to create a revocable trust. But before I get to that, if you have any questions about estate planning or any questions about probate, you can go to aubreylegal.com and schedule a time to talk with me for free on the phone. So today's topic is 3 reasons to create a revocable trust. This is a common question that I get from potential clients. During our initial meeting. A lot of times the meeting starts off with saying, I have X, Y, and Z asset, or I own this business, or I own this house. Do I need a trust? And the question becomes, it depends. It's a very common answer you get probably from a lot of lawyers when you ask them a question, but in this case, it truly is the answer to that question. And why it depends? Well, it depends on what your estate planning goals are. And does the trust accomplish those goals? And if it doesn't accomplish those goals, it probably doesn't make sense for you to create a trust. But if it does, then the trust will probably be the right strategy to use. Because not everybody needs a trust. And for everybody, a trust isn't the right strategy that they want to implement. So they don't have to do it. There is really no threshold or no bright line where if you have this type of assets or you have this net worth that you need to have a trust. It may make sense to have a trust, but you don't have to have it if it doesn't fit what you want to do with your estate plan. So the three reasons to create a trust. The first is to avoid probate. This is a very common goal for a lot of people in estate planning, is they don't want to go through the probate process. And what is probate? Probate is the process where you transfer your assets to someone else when you die. It's really just a mechanism how assets get transferred. The process can be long, it can be expensive. It's overseen by a court. So a lot of people want to avoid this. They don't want to have their family go through this after they die. So they say, let's create a trust. And what allows us to do is that during your lifetime, you create a revocable trust and you transfer assets into those trusts. And how do you do that? You change the title of those assets from you individually to the name of the trust. Therefore, when you die, you don't own that asset. Therefore, it doesn't have to be settled by your estate. It does not go through probate. The trust owns that asset. So once you die, if the asset's held in trust, you don't have to probate that asset. So really the best way to avoid probate is through a trust. There are other strategies you can use as well, such as beneficiary designations or transfer and death accounts. Those avoid probate as well. But there are some limitations to those strategies, and the next reason to create a trust kind of addresses that concern. So the next reason to create a trust is to dictate or control how assets are transferred to your beneficiaries. With a trust, you're able to determine or dictate how the assets are transferred, when they're transferred, and in what manner. So, for example, you could create a trust where assets are transferred to your daughter when she turns age 25. She receives $100. So that's what the trust will say. So if you die and there's assets held in trust for the benefit of your daughter, let's say it's $100. When she reaches age 25, receive that money. You can also stagger it too, so that she can receive a third of the trust at age 25, another third at 30, and then another third at 35, whatever the case may be. The ages are completely flexible. You can do whatever you want. You can also have the trust so that they don't receive any principal of the. They don't have the ability to withdraw any principal in the trust until they're age 50. And this can be, if this is what you want, this is what you can do. You're also allowed to structure the trust so that prior to that age 50, then in the example, is that the trustee is allowed to make discretionary distributions, for health, education, maintenance, or support. So what that means is that, since they don't have any right to withdraw principal until the age of 50, but if they want to, go to college or, maybe, use money in their trust for a down payment on the house, then they can go to the trustee and say, hey, I'd like to do this. And the trustee is able to make that distribution based on the fact that it's for health, education, maintenance, or support. However, if the trustee, if the beneficiary went to the trustee and said, hey, I want to buy a new car and I want it to be a Ferrari, well, the trustee has discretion to say, no, that's not really, I think in your best interest. So what we're going to do is we're going to give you $20,000 so you can buy a different type of car that's more reasonable for someone your age. And one thing to consider when you create a revocable trust is that it really only comes into effect in two instances. Number one is when you're incapacitated. So what that means is that if you're incapacitated, your successor trustee will step in and manage your trust while you're incapacitated. And then once you're able to manage your own affairs again, you'll become you're the trustee, and you'll be managing the trust. And the other instance is when you die. So before if those two instances don't happen, then the trust never really comes into play. So if you're worried about, if I have this trust where my child gets money when they're age 25, but if I'm still living, will they get that money? No, that's not the case. It only happens, the distributions only take place after you die. So that's something that if you're concerned about, the revocable trust does not, allow that to happen. And then the third reason to create a trust is for privacy. This is usually less important to a lot of people. Is that they want to keep things private. The one thing about a trust is that there's no central place where you have to register your trust. So it's not public record anywhere. So people don't know what's in the trust, who the beneficiaries of the trust are. There's no public recording of that trust. This is as a contrast to a will, because in a will, once you die, you have to probate that will and you have to file that will with the local court. And anybody can walk into the courthouse and talk to the clerk and get information on what the status of the case are, so they can see what assets are being transferred, who they're being transferred to. So if privacy is important to you, then a trust is definitely something that you want to consider as part of your estate plan. So just to sum up, the three reasons why you would want to create a trust is: one, to avoid probate; two, is to have control over how your assets are distributed to your beneficiaries; and then third is to have some level of privacy that a will does not offer to you. So that's all I have for you today. Again, my name is Scott Aubrey. I'm the owner of Aubrey Law. If you want to talk to me about estate planning or probate, you can go to aubreylegal.com and schedule a time to talk with me for free. Thank you for taking the time to watch this video. I appreciate it. I appreciate you, and I will talk to you again soon.